sort of these aberrations cannot result in the provision being declared unconstitutional, even if there were a constitutional challenge. But more importantly, these are, of course, there are these exceptional cases where you will have a small transport vehicle as opposed to a heavy SUV for which the driver. But look at the purpose. Somebody who is driving an SUV, the presumption which the law makes is that you're not driving it for, it's not in the nature of, say, a school bus, or you're not driving it for carrying of goods or passengers for hire or reward. The purpose is very different. The nature of the people who are in the car is different. You will have a small transport vehicle as opposed to a heavy SUV for which the driver. But look at the purpose. Somebody who is driving an SUV, the presumption which the law makes is that you're not driving it for, it's not in the nature of, say, a school bus, or you're not driving it for carrying of goods or passengers for hire or reward. The purpose is very different.
The statutory scheme. But then to use this to interpret the statute will be, reversing it. Your purpose is to only for interpretation, right?
Lordship, please.
That we should not be doing it. We can't.
So my limited submission is
executive interpretation. Motor Vehicles Act.
What happens if this is categorized as transport vehicles, and tomorrow, if unfortunately this vehicle meets an accident, and just because the person is holding an LMB license, he will not get the claim. The claim will be repudiated, even if it is a personal vehicle.
License, it doesn't. This execute doesn't entitle somebody for a licensing or licensing. It doesn't work like that.
I mean, just to what is transport and what, this is the only place where it has been categorized as transport and non-transport vehicle. Where Lordship will find a personal vehicle also being categorized as non-transport vehicle, which would ultimately come to the rescue of person if he is driving it or using it as a transport vehicle, and if it meets with an accident. To recover his claim and say that the vehicle was for personal use.
But one other thing, any of these under the non-transport vehicles are used for purposes other than a personal purpose, then the other provisions, statutory provisions, get retracted. So it's not applicable across the board.
I appreciate
to define a non-transport.
I appreciate. Okay. This is the only distinction in the Act.
How do you formulate it in your submissions? Let us see your submissions, so that we'll then you can leave the point after we've read your submission on this.
Because I was reading para 5.
Para 5 already.
Page 2. It is clear that legislative intent is clearly to replace above said classification with single class of transport vehicles. This was 94. Thus, the expression transport vehicle would include only the heavy goods vehicle, as in section 216, heavy passenger motor vehicles, as in section 2, clause 17, medium goods vehicle, as in section 2, clause 23, and medium passenger motor vehicles, as in section 2, clause 24. However, the classification of LMB remains unchanged in section 10, clause 2D as a separate class. In fact, Mukund Devangan also holds similarly. Para 6, therefore, the three-judge bench in Mukund Devangan has rightly held that the legislative intent behind the omission of clauses E to H from section 10(2) of the MV Act 88, insertion of expression transport vehicle in section 10, clause 2E, is to give effect to the provisions of section 3 of the Act, which requires that a person, in order to drive a transport vehicle, must have authorization. Once a license